editorial which published in Times of India, which is related to CA. So, title of this editorial is CA is necessary. Why the many argument about its being unconstitutional don't hold water. The controversies, the Citizenship Amendment Act, appear to simmer and of late has led to the communal right. I have failed hopelessly to comprehend what the controversy is all about. Illegal migrants are deported under the Foreign Act 1946 and its Citizenship Act 1955. The procedure of identify illegal migrant in the Northeast was criticized and for good reason. But the law that require Muslim migrants from Pakistan and Bangladesh to be deported is the law of 1946 and 1955. If the CAA goes away, Muslims from Bangladesh and elsewhere who are illegal migrants would be liable to be deported as would illegal migrants who are Sikh, Buddhist or Christian. The citizenship of the country is presently based on the similar principle followed in almost all countries governed by the rule of law. Citizenship is acquired by birth, descent, naturalization, or by acquisition of territories. Those who seek to enter a country without its permission are illegal migrants and are liable to be deported. The demographic consequences of the Bangladesh war in the northeast leading up the Assam Accord resulted in enactment of Illegal Migrant Act, which made it practically impossible to identify and removal of illegal migrants. This law was successfully challenged by those who claimed that it was a betrayal of the Assam Accord, and Supreme Court in Sonowal case taking the government to task of the feature identify and deport illegal migrants. It is the case that the idea of detention center are mooted. The Citizenship Amendment Bill 2016 was introduced in the Lok Sabha on 19 July 2016 and was referred to the Joint Committee of both Houses of Parliament, which presented its report on the 4th of January 2019. Recommending the bill, the rule framed in 2003 provided for the creation of National Register of Indian Citizens to be writing up, carrying out throughout the country's house to house enumerations, and which doubtful cases were to be noted separately for further inquiry. These rules have been in place of the last 16 years but are yet to be operationalized. I fail to understand how a law which is designated to confer the benefit to an identified class of person and which identification is based on the rational criterion can be condemned as being discriminatory on the ground that the legislation could have created a wider class arrived at was applied to the broader criterion for identifying the class of those who would benefit by the legislation. The principle of equality does not mean that every law must have universal application. The principle of equality does not take away from the state power in making the classification. If the law deal equally with member of the defined class, it is not open to the charge of denial of equal protection on the ground that it has no application to other person. The Supreme Court has repeatedly held that court cannot interfere simply because the method are also possible, even if the court think that they are the better for India, and the government must be left to determine which of the many possible scheme is the best. CA award objective is to enable conformment to Indian citizenship among members of the minority communities who hail from Afghanistan, Bangladesh and Pakistan. Do we really need proof that minority are persecuted in these Islamic republic? How can parliament be faulted for the coming to be conclusion that such minorities in three names never need to be protected? Classification on the basis of the religion is not for the unconstitutional. It is worth reminding ourselves that our constitution confers a special right upon the member of minority religions communities in India. If the law was broader and allow members to the religious communities from Pakistan, Bangladesh, Afghanistan or migrate into India, we could, as we do, away with our border. And even more tenuous argument is finding the discrimination as the law does not extend of every citizen of every country or same country who has suffered religious persecution. The boldest lawyers have not gathered courage to advantage any such argument. Their disadvantage, of course, was that they were not TV anchor or entitled enlightened member of the civil society protesting on the street. The loudest criticism related to the supposed intention of the government to the throw of Muslim out of the India. There is no law, rule or notification published or even a draft circulated that would suggest the government had any such intent. The Prime Minister has denied it. If any procedure put in place require Muslim alone all over India to prove their citizenship in a manner more onerous onerous than that application to any other community such as the procedure would be unconstitutional. Taking a special measure to address demographic distortions caused by the Bangladeshi conflict in the defined geographic area. These measures could be made the template for the rest of India's shown ignorance of the basis of rule of law. Polarization between the caste caste and the religion is the old least notion of the modern India. I also find the growing polarization between those who have enjoyed the prerequisite of power over the decade and between those who have replaced them. Add six mixed to the fact that certain ideology which are what dust on the bookshelf of political history in the country of the origin continue to be more romanced by the intellectuals, some of the whom dominate civil society and civil disclosure, all the create a fertile ground, protest and arrested debates, and when it comes romanticizing such movement, perhaps the feeling is why let the truth spoil a good story. So this is all about today's editorial. I hope you enjoyed. Thank you.